California Medical Association. I want to thank the CCIA and Cal Heritage for inviting me and the CMA to participate. I wanted to also thank Mr. Cooley, but he's no longer with us. I would encourage everybody as you go the rest of your days, the rest of your day here at the informational hearing or later at some of the evening events. If you run into any of the legislators, I would just really strongly encourage you to give them a note of thanks. The legislative package might not have been perfect from everybody's perspective. You might didn't get everything you wanted, but I got to tell you, this particular effort here with these particular legislators, I got to imagine they earned their paycheck on this one, and I got to think that at sometimes they were sort of wondering what exactly did they get themselves into as they were pushing this last year. Wouldn't surprise me if that was that thought crossed their head. Just following sort of Paul's outline, I'm going to kind of talk about who CMA is, kind of what got us into this issue, and then looking at the legislation, and then sort of looking forward, things we'll be kind of keeping our eye on here. The California Medical Association, we represent over 41,000 physicians, residents, medical students. That's about over half of the active practicing physicians in California. We're one of the larger state medical societies in the country. There's a lot of talk about local control, environmental impacts, taxation, what have you. But it's easy to forget at the end of the day, all of this work and effort centers around getting patients access to a drug that has the potential to help them. So CMA's been looking at this issue for quite a while. Back in 2011, we made a big splash in the media. We were the first medical association to really take a strong stand on issues related to medical cannabis. We issued a report and a policy that really called for three things. It called for the federal rescheduling of marijuana in order to encourage research and to responsible regulation. We called for regulating and taxing recreational cannabis in a manner similar to tobacco and alcohol. And then we also encouraged greater promotion of the risks and benefits of cannabis use. Now, to the first point, everyone here knows federal law classifies cannabis, marijuana, as a Schedule I drug, meaning it has no accepted medical use and a high potential for abuse. This designation, alongside substances such as LSD and peyote, have severely limited research not only on the potential therapeutic usefulness of cannabis, but more importantly in some cases, the potential risks of cannabis and its various chemical components. What this designation also does is it means that physicians are not allowed to prescribe marijuana. And I mean more than just writing something on a piece of paper. Prescribing entails everything that's involved with our prescription drug system as we know it. The standardizations, the delivery process, all of that simply not allowed because of this designation. The Schedule I designation really serves, creates a number of policy challenges for physicians. Because of this, and because of California law, which allows a physician to recommend medical marijuana, California law has inappropriately, we feel, placed physicians in the role of a gatekeeper. And what I mean by that is those wishing to access cannabis and avoid criminal penalties, they currently look to physicians for a recommendation of medical cannabis. But unfortunately, the popular justification for decriminalization has been a declaration of medical efficacy of cannabis, when in reality the data is much more mixed. We believe there's still a lot of work to do to address potential benefits and risks with this largely unstudied botanical and its chemical components. To that end, SB 643 does task the Center for Medicinal Cannabis Research and the Medical Board to work together on developing some criteria on marijuana's applicability in medical practice. Clearly, it seems clear that cannabis components may have some efficacy for treating pain, nausea, other conditions, but the literature is inadequate and the dosage is not well standardized. And also, of course, important to note, until the passage of this legislation, there's really not a lot of labeling standards or dealing with concentration and purity. Imagine this in a traditional medicine scenario where you pick up a prescription from a pharmacy, the capsules are different shapes and sizes and colors with different formulations in each pill, and instead of that lengthy drug information insert you would just get a picture of the guy, the emoticon guy, shrugging his shoulders, saying, good luck to you. Thankfully, we're not going to have to endure that much longer. Obviously, as legislative requirements on the regulatory scheme come into place, that patients should be well armed. Three major components that dealt with the medical practice and medical marijuana from our end that I'd just like to highlight. The priority enforcement of the medical board. Throughout the debate on 266 and the other bills and previous legislation, many stakeholders expressed concern with what they felt were inappropriate medical marijuana recommendations by some physicians. And some felt that we ought to limit the conditions or circumstances that a physician could lawfully recommend marijuana. We didn't agree with that approach. We felt like that was legislating the practice of medicine, as we call it. And we argued that to some extent, if somebody is acting outside of what the standard definition of medical care within the medical community, they should. The correct mechanism is the Medical Board of California, which enforces medical standards. So ultimately, that was where this legislation decided to go. It amended a business profession code, which essentially gave the medical board priority cases to enforce against. So repeated inappropriate medical marijuana recommendations will now be one of the medical board's tasks. The legislation also protects patients against inappropriate influences on physicians. California is one of a few states that essentially prohibits physicians from working for non-physicians, right? We don't want corporations and employment circumstances to guide a physician's decisions. And so in this case, we don't want a physician to be incentivized to recommend marijuana and then send a patient to a dispensary that he or she has a financial interest in. We think that's inappropriate. The legislation sort of codifies, bans that practice further. And then, a strict disclosure requirement on advertising on medical cannabis recommendations. Our review, there were some advertisements which we thought sort of pushed the line, may have suggested it's sort of almost a guarantee of a medical marijuana recommendation. Obviously, that's not appropriate. It needs to be reviewed, and a physician needs to determine whether or not medical cannabis is appropriate for you. As far as the next steps, I mean, definitely second what a lot of folks said about watching the implementation. That's very key. Primarily, that's going to be our position kind of going forward. But wanted to take advantage of this opportunity, given this unique set of stakeholders here. The CMA has been calling for this federal one rescheduling for quite some time now, and regrettably, we haven't really gotten very far with the federal government. We think it would be a particularly strong statement if a diverse stakeholder group such as this were to join us in calling for this rescheduling. The mere fact that we are here discussing a medical marijuana scheme should suggest to us that the Schedule I designation, which acknowledges no medical benefit, is wholly inappropriate for this substance. So we'd really encourage folks to join us in that. There was also one aspect which we suggested in the legislation which didn't ultimately get included, but we think should be at some point, is to require the Department of Public Health to really produce a brochure, a patient brochure that really gets into the risks and benefits of cannabis use. I think our members feel as though there's a miseducation going on somewhat, that patients are given mostly positive news about the potential upsides of marijuana, and very rarely do they hear about the potential negative consequences, of which there are several. And so, as with any drug or treatment, there's risks and benefits, and we feel like patients really need to be afforded the full knowledge of that. That's all for me.